So the standard in trademark law is confusingly similar. So if you've got a name and you're covering certain goods and services, no one can use that name, even if the goods and services are a tiny bit different. No one can use a name that is somewhat close to that. Like I said, the standard is confusingly similar, and that is a somewhat subjective standard, but that's how the trademark office analyzes it. So if they change one letter or two letters, or they make it plural, or they put the greatest whatever in front of your name, they're probably going to be too close to what you're doing. So you are able to exclude them from that space. They probably will be allowed to. So if you've got, if you're an auto mechanic shop on the one hand, and then somebody else is trying to sell sneakers, those names are, and it's the same name. Nobody's going to think that the automobile shop is starting to also sell sneakers. Now there is an exception to that, which one example would be Nike. If you've got a name that is so famous that you don't want anyone diluting your name, like I said, Nike, if somebody wanted to come along and open Nike automobile shop, they wouldn't be allowed to do it because Nike has additional protections under the anti-dilution statute, and that allows them to prevent anyone from potentially diluting their mark. This is only for very famous marks, and most marks don't quite reach that level.